Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
We have three judgments in this case. There's one judgment by me speaking for Brother Justice Rishikesh Roy, Justice Pardiwala, Justice Manoj Mishra, Justice Rajesh Bindal, Justice Satish Chandra Sharma, and Justice Augustine Masi. Then there is a second judgment by Sister Justice Nagaratna, which is partially concurring. And there is a dissent by Justice Dulia. So I'll just read out relevant parts of my judgment. The issues that arose for our consideration are A. Article 31C. Whether Article 31C, as upheld in Keshavananda Bharati, survives in the Constitution after the amendment to the provision by the 42nd Amendment was struck down by this court in Minerva Mills. And B. Article 339B. Whether the interpretation of Article 39B adopted by Justice Krishna Iyer in Rangaraj Reddy and followed in Sanjeev Coke must be reconsidered. Whether the phrase material resources of the community in Article 39B can be interpreted to include resources that are owned privately and not by the state. On the first question, we hold, and on this we are all unanimous, there is no divergence of opinion on the first aspect. On the first question, we hold that Article 31C, to the extent that it was upheld in Keshavananda Bharati, remains in force. After tracing the history of Article 31C and the precedents concerning the invalidation of amendments, we observe by Section 4 of the 42nd Amendment, the words "the principles specified in clauses B or C of Article 39 in Article 31C were replaced with the words "all or any of the principles laid down in Part 4. This is a case of substitution. Section 4 of the 42nd Amendment was subsequently struck down in Minerva Mills. As noted above, where an amendment substituting certain text with certain alternate text is invalidated, the effect is that the unamended text continues in force. This is because the legislative intent of repeal and enactment in such cases is composite and cannot be separated. To give effect to the repeal and not the enactment would result in an outcome which does not correlate with legislative intent, and as Justice Hidayatullah noted in Lakshmi Bai's case, leave the original section truncated, resulting in absurd outcomes. This would in effect invalidate the original valid and constitutional provision, despite there being no constitutional fault with it, nor the legislature intending to repeal it. Thus, the presumption would be that after Minerva Mills, the unamended Article 31C would continue in force. Indeed, it is evident that such cases as Bhim Singh and Sanjeev Coke proceeded on this presumption. The only plausible exception to this presumption would be if it could be demonstrated that Parliament, when enacting the 42nd Amendment, would have repealed the words "the principles specified in Clause B or Clause C of Article 39, independent of their enactment of the words "all or any of the principles laid down in Part 4. In this case, no reference to the broader legislative proceedings or external aids is necessary to arrive at the inference that Parliament would not have independently repealed these words. The text of the amendment adopted by Parliament itself makes it abundantly clear that there was no independent intention to repeal. The effect of Section 4 of the 42nd Amendment was to expand the scope of the immunity provided by Article 31C to legislation. Under the unamended Article 31C, immunity was only provided to legislation if it gave effect to the directive principles found in Clause B or Clause C of Article 39. However, by Section 4 of the 42nd Amendment, the scope of this immunity was significantly expanded to immunize legislations that gave effect to any or all of the directive principles in Part 4 of the Constitution. Thus, the intention of Parliament in enacting Section 4 of the Constitutional Amendment was undoubtedly to expand the scope of the immunity granted by Article 31C. This being the situation, it cannot be suggested that Parliament would have repealed the words "the principles specified in Clause B or Clause C of Article 39 if it did not simultaneously enact the broader language expanding the scope of Article 31C. If Parliament had independently repealed these words, it would have not just reduced the scope of Article 31C, but altogether eliminated the effect of the article. Without the words "the principles specified in Clause B or Clause C of Article 39 and Article 31C, the provision would have been rendered nugatory. Given Parliament's manifest intention to expand the scope of Article 31C by Section 4 of the 42nd Amendment, it is not plausible to hold that Parliament independently sought to repeal the words, the principle specified in Clause B or Clause C of Article 39 from Article 31C. Therefore, it is evident that the legislative intent of Parliament when adopting Section 4 of the 42nd Amendment was composite to repeal and enact, that is, to substitute through one single action. This court cannot therefore disaggregate the steps of repeal and enactment and give effect to the repeal even after invalidating the enactment. After Minerva Mills invalidated Section 4 of the 42nd Amendment, the composite legal effect of Section 4 is nullified and the unamended text of Article 31C stands revived. The final question is whether the revival of the unamended text of Article 31C would in some way manifestly contravene the principles laid down in the judgment in Minerva Mills or result in some other adverse consequence. The text of the unamended Article 31C was challenged, and the first part of the article was held by the 13-judge decision in Keshavananda Bharati, while the latter half of the article was invalidated. Therefore, the first half of the unamended Article 31C, which is the subject matter of the present controversy, was undoubtedly constitutional as held by the 13-judge decision in Keshavananda Bharati and further by the Constitution bench in Vaman Rao. Therefore, if as a consequence of the decision in Minerva Mills, the unamended Article 31C continues in force, there can be no question of any unconstitutionality or adverse consequences associated with the unamended Article 31C. Indeed, both the Constitution benches in Minerva Mills and Vaman Rao expressly noted that the first half of Article 31C had been held to be constitutional in Keshavananda Bharati. Given that the unamended Article 31C has been given effect to for over 4 decades, as demonstrated by the decisions of Bhim Singh and Sanjeev Coke, no argument can be raised concerning any legal or practical difficulties with the operation of the unamended Article 31C. Given these findings, we conclude that the unamended Article 31C continues in force. On the second issue, concerning Article 39B, we first look at the question of judicial propriety and discipline and then determine the correctness of the judgments which have been doubted by the reference on their merits. We observe that there is a distinction between holding that private property may form part of the phrase material resources of the community and holding that all private property falls within the net of the phrase. It is here that the judgment by Justice Krishna in Rangaraj Reddy and the consequent observations in Sanjeev Coke fall into error. Justice Krishna cast the net wide, holding that all resources which meet material needs are covered by the phrase, and any attempts by the government to nationalize these resources would be within the scope of Article 39B. He clarified that not only the means of production, but also the goods so produced fall within the net of the provision. The illustration which he provides on Rangaraj Reddy indicates the unworkable nature of such an interpretation. Justice Krishna observed by way of an illustration that not only do factories which produce cars fall within the net of Article 39B, but even privately owned cars are covered by the provision. Similarly, even in Sanjeev Coke, the net is cast wide, and this court observed that all things capable of producing wealth of the community fall within the ambit of the phrase. In both decisions, it was observed that all resources of the individual are consequentially the resources of the community. An interpretation of Article 39B, which places all private property within the net of the phrase material resources of the community, only satisfies one of the 3 requirements of the phrase. That is, that the goods in question must be a resource. However, it ignores the qualifiers that they must be material and of the community. The use of the words material and community are not meaningless superfluities. We cannot adopt a construction of the provision which renders these terms ocious. The words of the community must be understood as distinct from the individual. If Article 39B was meant to include all resources owned by an individual, it would state that the ownership and control of resources is so distributed as best to subserve the common good. Similarly, if the provision were to exclude privately owned resources, it would state ownership and control of resources of the state instead of its current phrasing. The use of the words of the community rather than of the state indicates a specific intention to include some privately owned resources. In essence, the text of the provision indicates that not all privately owned resources fall within the ambit of the phrase. However, privately owned resources are not excluded as a class, and some private resources may be covered. The resource in question must meet 2 qualifiers. That is, it must be a material resource, it must be of the community. Thus, the judgments doubted in the reference before us are incorrect to the extent that they hold that all resources of an individual are part of the community.
Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
Are part of the community, and thus all private property is covered by the phrase material resources of the community. The interpretation amounts to endorsing a particular economic ideology. To declare that Article 39B includes the distribution of all private resources amounts to endorsing a particular economic ideology and structure for our economy. Justice Krishna's judgment in Rangaraj Reddy, which was followed inter alia in Sanjeev Coke and Bhim Singh Ji, was influenced by a particular school of economic thought. This is evident from various observations made in these judgments. For instance, in Rangaraj Reddy, Justice Krishna observed that Article 39B constitutes a directive to the state with a deliberate design to dismantle feudal and capitalist citadels of property. In Bhim Singh Ji, Justice Krishna cited Karl Marx in his judgment to observe that taking over large conglomerations of land is necessary to make Article 39 a constitutional reality. Interestingly, in the same decision, the learned judge also expressed his view about the nature of the economy and observed that our economy was in the transitional stage, undergoing a Fabian transformation. Similarly, in Sanjeev Coke, Justice Chinnappa Reddy stated that the words and thought of Article 39B but echo the familiar language and philosophy of socials as expounded by all socialist writers. In a sense, the interpretation of Article 39B adopted in these judgments is rooted in a particular economic ideology and the belief that an economic structure which prioritizes the acquisition of private property by the state is beneficial for the nation. Significantly, both Justice Krishna in Rangaraj Reddy and Bhim Singh Ji and Justice Chinnappa Reddy in Sanjeev Coke consistently referred to the vision of the framers as the basis to advance this economic ideology as a guiding principle for the provision. However, as noted earlier in this judgment, the vision of the framers while drafting the Constitution was not to lay down a particular form of social structure or economic policy for future governments. The debates in the Constituent Assembly reflect the foresight of Dr. B.R. Ambedkar. He was categoric in his constitutional vision. The Constitution and the directive principles as he expounded in their fundamental principles rejected the prevalence of one dogma. The Constitution was framed in broad terms to allow succeeding governments to experiment with and adopt a structure for economic governance which would subserve the policies for which it owes accountability to the electorate. According to Dr. Ambedkar, if the Constitution laid down a particular form of economic and social organization, it would amount to taking away the liberty of the people to decide the social organization in which they wish to live. He opined on several occasions that economic democracy is not tied to one economic structure, such as socialism or capitalism, but to the aspiration for a welfare state. Thus, the role of this court is not to lay down economic policy, but to facilitate this intent of the framers to lay the foundation for an economic democracy. Indeed, it is this spirit and its all-encompassing nature of the Constitution which has allowed elected governments since independence to pursue economic reforms and policies based on domestic conditions, international requirements, and political exigencies of the time. At the time of independence in the 1950s and 60s, given the earlier challenges of our republic, the focus of the government was on planning a mixed economy, heavy industries, and import substitution policies. Subsequently, in the late 1960s and 70s, there was a shift towards purportedly socialist reforms and policies. Since the decade of the 1990s or the liberalization years, there has been a shift towards pursuing a policy of market-based reforms. Today, the Indian economy has transitioned from the dominance of public investment to the coexistence of public and private investment. The doctrinal error in the Krishnaya approach was postulating a rigid economic theory which advocates for greater state control over private resources as the exclusive basis for constitutional governance. India's economic trajectory indicates that the Constitution and the custodians of the Constitution, the electorate, have routinely rejected one economic dogma as being the exclusive repository of truth. As participants in a vibrant, multi-party economic democracy, the people of India have voted to power governments which have adopted varied economic and social policies based on the country's evolving development strategies and challenges. The foresighted vision of our framers to establish an economic democracy and trust the wisdom of the elected government has been the backbone of the high growth rate of India's economy, making it one of the fastest growing economies in the world. To scuttle this constitutional vision by imposing a single economic theory, which views the acquisition of private property by the state as the ultimate goal, would undermine the very fabric and principles of our constitutional framework. We therefore conclude A. Article 31C, to the extent that it was upheld in Keshavananda Bharati versus Union of India, remains in force. B. The majority judgment in Rangaraj Reddy expressly distanced itself from the observations made by Justice Krishna Iyer, speaking on behalf of the minority of judges on the interpretation of Article 39B. Thus, a co-equal bench of this court in Sanjeev Coke erred by relying upon the minority opinion. C. The single sentence observation in Mafatlal to the effect that material resources of the community include privately owned resources is not part of the ratio decidendi of the judgment. Thus, it is not binding on this court. D. The direct question referred to this bench is whether the phrase material resources of the community used in Article 39B includes privately owned resources. Theoretically, the answer is yes. The phrase may include privately owned resources. However, this court is unable to subscribe to the expansive view adopted in the minority judgment authored by Justice Krishna Iyer in Rangaraj Reddy and subsequently relied on this by this court in Sanjeev Coke. Not every resource owned by an individual can be considered a material resource of the community merely because it meets the qualifier of material needs. E. The inquiry about whether the resource in question falls within the ambit of Article 39B must be context-specific and subject to a non-exhaustive list of factors such as the nature of the resource and its characteristics, the impact of the resource on the well-being of the community, the scarcity of the resource, and the consequences of such a resource being concentrated in the hands of private players. The public trust doctrine evolved by this court may also help identify resources which fall within the ambit of the phrase material resource of the community. F. The term distribution has a wide connotation. The various forms of distribution which can be adopted by the state cannot be exhaustively detailed. However, it may include the vesting of the concerned resources in the state or nationalization. In the specific case, the court must determine whether the distribution subserves the common good. The reference is answered in the above terms. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate bench.
One of the greatest American judges, Justice Benjamin Cardozo, in his book, The Nature of Judicial Process, said, and I quote, "The great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges by," unquote. In the field of constitutional law, progressive and dynamic interpretation of the Constitution in light of the socio-economic developments in the country must dominate. To such an organic text as the Constitution of India, a flexible interpretation must be given which the changing times require. Neither can there be canonization of the socialist policy followed by the state, nor can the principles akin to laissez-faire economics be ignored at a time when they have been resurrected by the state itself to soothe the developments of the economy in the country and for the benefit of the people of India. Chief Justice Earl Warren's statement is apposite and as a reminder to our judicial conscience. Quote, "Our judges are not monks nor scientists, but participants in the living stream of our national life, steering the law between the dangers of rigidity on the one hand and the formlessness of the other. Our system faces no theoretical dilemma, but a single continuous problem: how to apply the ever-changing conditions, the never-changing principles of freedom. Can principles of liberalization, privatization, and globalization adopted in India since the year 1991, reforms in the economy, and structural changes that have been brought about in these last 3 decades hold a mirror against the socio-economic policies that were followed in the decades immediately after India attained independence? As a result, can the judgments of this court, which interpreted the Constitution to be compatible with the policies of the state, then be considered to be a disservice to the broad and flexible spirit of the Constitution and the authors of the said judgment being critiqued today? I have perused the erudite and comprehensive opinion authored by Honorable the Chief Justice of India, Dr. Dhananjaya Y. Chandrachud, on the questions referred to this 9-judge bench. I have also perused the opinion proposed by learned brother Justice Dhulia. The letter and spirit of the judgment of the learned Chief Justice has ignited me to pen a separate opinion, concurring with his opinion on certain issues, while giving my own views on certain other aspects, which is also my response to learned brother Justice Dhulia's views. How does ownership